they were giving him, you know, a series of catheters so that he can treat because he was not having to go to the medical floor. And then there was some allegation or some type of something where he was supposedly hoarding them and trading them. I'm like, what happened with that? And so
Um,
it would make sense that if they gave him 10 for a certain period of time, there wouldn't be documentation every single day.
thank you. And the court brought that up, and part of my serious frustration with this matter is that comment was made by Gabby on the record.
Miss Young.
Yes, Miss Young. I'm sorry, Miss Young from the Jacksonville Sheriff's Office, who seems to have taken on the role of counsel of NAVCARE, even though NAVCARE has their own lawyers. She made that comment. I questioned her about that comment. She said, "Oh, that's what I've been told." And I said, "Well, do you have any proof of that? Would you please send me something that would show that? Because that would something that you've now put on the record that the court now, after numerous days, remembers it well." It didn't happen, Your Honor. And that was my frustration with this.
Okay.
Ms. Young, so there was none of that. There's no documentation of that. There's no support of that.
Okay.
That's my frustration with having Ms. Young appear by Zoom and make allegations that are not supported by the evidence, being a observer in this case, not counsel and not a witness. So that was my frustration with that. And the court recalls it, which makes my point that this has taken a different direction. I thank the court for bringing it back to the point. This is about my client's medical care.
All
So
right.
thank you, Your Honor, for bringing it back to that. So
So
that's my
so there are no so y'all vetted it. So I remember when that happened, we recessed it. I gave you time to investigate it or look up or so that is not an issue.
correct.
Correct.
Uh,
Okay, so it's not an issue on either side. All right, so to me that's over with or done. Okay. And so this has been going on
it has.
for 60 days. Like it's been going on so long. What what is the current status of what is going on with him now? Is he getting his catheter kits and is he self-administering or what is the status of his care now?
He
And
is.
is it still causing the defense this concern that, you know, he's in grave medical danger in the jail?
Yes, Your Honor. He is getting it on a much more regular basis now. I will say that since this has happened, he has been getting he goes down, they make him count it out. He gets them and he self-administers. And that portion is right now going the way it should. Just like it did with his 3 previous UTI infections when they were not treating him properly and not giving him the right medicine. But once it became an issue and he went to the doctor, went to Shands, and we have the reports of that are undisputed reports of that, going to the doctor, having UTIs, having blood in his urine, and going there, when there's pressure on them, they comply. And for a couple of weeks, a week or two after the UTIs, and while this has been pending, they do their best to make the court happy and Ms. Young happy and NAVCARE happy. Our concern is we don't know what's going to happen over the Christmas holidays, if they're going to go back to their old ways. But presently, he has since this 60 days, he has fallen. He has had a fall that resulted in a black eye that I personally saw. He has this new infection, new spider bite that is going on with him. What we're here is not for a typical bond hearing. We're here for a compassionate relief hearing. I know that we talk about we normally do 150,000 for this charge. We normally do this for this charge. That's not what I'm trying to do. We're not here for a bond reduction or a setting of a bonds. I'm here to ask the court for compassionate relief due to the medical situation. We know he's not a flight risk. We know he's never been arrested before in his life. He's not a criminal aspect of it. This is a case where I'm asking the court to let him go home on house arrest. I mentioned having an additional bond with it just for the comfort level of the state and the court that if something were to happen, we would tend to the passport, but even if something were to happen, at least a bondsman could go to find him. We're asking that he be treated at home, be allowed to be at home where he can be taken care of by his mother. You've seen the mother come repeatedly, the daughter come repeatedly. We're asking the court for compassionate relief to let him go home. He can Zoom for all the court appearances. He can go to his doctor visits. He can have the surgeries and the caretaking that he needs to have. There was some concern of sepsis previously. Looking at paragraph 17, 18, and 19 of my motion, things that are not disputed, he's had a series of medical problems that are not going to get any better. Your Honor runs a very efficient courtroom. This is not going to go on until June or July. The case is going to reach its natural conclusion within 30 to 90 days, maybe 4 months on max. I'm asking that he be allowed to go home during the course of this so that he can be treated properly, medically. He's not fleeing. He's not going to hurt anybody. That's what we're asking the court to do, Your Honor. So that's why I'll take your questions at this point.
Well, let me hear from the state.
Yes, Your Honor.
So what is the state's position related to this? I mean, it's not completely unheard of. However, the times that the court has done it is that it has been essentially certified through JSO. Like, for example, I had a gentleman that had terminal cancer. He was, I mean, by the doctors, had basically only a short time to live. And everyone agreed on that one. And so I did grant compassionate release in that particular situation. So I'm what you're asking for is not completely unheard of, but generally speaking, there is kind of a medical basis for it from the sheriff's office. They are saying they are able to manage his medical care. And I know it's maybe not to the standard that the defense would like or request, but that's kind of what I'm balancing or weighing. Okay, so let me hear from the state.
Yes, Your Honor. Well, first, the state wholly disputes this characterization of old ways by the jail. Speaking specifically to paragraph 12 of the defense's amended motion, I was able to go through A, B, C, all of these letters. Um, I didn't make it through all of them, but the majority of them, Your Honor, I can tell we factually disagree with this. And the medical records, there are pages here. Just for Your Honor's reference, there is a set of pages around page 202, and there's a set of pages around page 468. So there are two separate medical records taking place. I believe it's broken up into daytime and nighttime care. But if you put those two together, this defendant has been receiving what he's required is 5 to 6 catheters daily. He's been receiving the majority of time at least 5, if not more. I of course agree that there are times he receives less and there are times there are not records, but the majority of time since September, when when the defendant's motion puts into question, is September 1st is the first date. He received 5 catheters that day. The next day he receives 3, but the next day he receives 9. Then he receives 6. And Your Honor is able to see that if you go through the pages and compare, let's say September 1st from the one set and September 1st from the second set. And you'll see he is most of the time receiving what he needs. So I'm not sure about this, the jail getting quote unquote caught and then needing to fix their ways. They've been doing what they're supposed to do the majority of the time. And most of the time that he receives extra, it's because he received less the day before. So even when he's receiving less, they're making up for it. For example, September 2nd, he received 3 catheters at 8 a.m. That's referring to page 202. But then immediately at midnight the next day, he receives 2, and then he receives 3 at 11 a.m. And then he receives 2 at 8 o'clock, and then he receives another 2 at 10 o'clock. So for that day alone, he received 9. So I don't believe there's evidence in front of Your Honor that is sufficient to grant compassionate release based on the catheter situation. He's receiving the care that he needs. And specifically, this motion was filed, the original motion, at the beginning of October. On October 2nd, 3rd, and 4th, he received 5 every day. And then the most recent the medical records end at, or at least the defendant's motions dates end at October 22nd. He received 10 catheters that day, 5 at 5:46 a.m. and 5 at 8 a.m. So as far as those allegations, they are factually incorrect based on the evidence that is of the medical records. As to the other allegations of why he should be granted compassionate release, I disagree that he's a flight risk. I disagree that he's a danger to the community.
Let me ask you this.
Yes, ma'am.
And I'm asking because I want to make sure that my recollection is correct. This the situation that leads him to this medical position, needing the catheterization, that predates the allegations made by the state, which is attempted second-degree murder.
Yes, Your Honor, and it's actually tied to this case. The motive, as understood by the state, is that Mr. Townsend believes he was shot. We know that that's what led him to this medical situation. That is because Mr. Townsend believed that our victim in this case, Mr. Walker, had set him up. There was supposed to be some sort of gun sale or something going on with a Sean Roundtree, who was somehow related to Mr. Walker.
Well, I don't need to know all the facts.
Ma'am.
I mean, my question's very direct. So this medical situation predates the allegations of the state.
Yes, ma'am.
So he would have been using these catheters from the state's position prior to his incarceration.
I don't have actual knowledge of that, but I would presume so. Yes, ma'am.
So you don't have his medical records
The only
in your case?
no, ma'am. The only medical records I have are his jail records from this hearing.
So the state is just straight objecting, is that right?
Yes, Your Honor. And a few things just to make the record clear. There are the exhibit that we just spoke about at the beginning. There's something about the NAFCARE documents. I believe, and defense can correct me if I'm wrong, I believe those are already included in the medical records. So when you're reviewing, they're kind of cumulative. And then as far as there are bonds that have not been set, so the state would disagree as to count one into any reduction of bond or compassionate release. The defense or the state did agree with defense yesterday that they will lower the bond on count 5 to 100,000. And then counts 2, 3, and 4 have not been set. And if Your Honor wants to hear from the state on those, now I can do that, or we can handle simply what we're handling before we go into those counts.
What's the bond on 5?
5 currently is 300,000. The state agrees to lower that to 100,000. Conditions remaining.
And you filed additional counts with different listed victims?
Yes, ma'am.
All right, Mr. Chris, I'm going to give you last word.
Thank you.
Okay.
Judge, by the state's own admission, there are some pages there are no documentation whatsoever. What we heard them say is one day, for instance, he got 2, but then they made it up for it later, or the next day they made up for it. Your Honor, understand, it is a catheter. It is when his bladder is full and when it causes pain that cause the 3 different UTIs that are undisputed that cause UTIs. Giving me 3 after I've gone 24 hours with 2 catheters, needing to use the bathroom when I'm prescribed 5 to 6, prescribed 6. Tell me how that minimizes his pain that he went through, because he only had 2 for 24 hours before he gets to the next day. They can give him a dozen the next day. It doesn't heal what happened to him on the day he only had 2. And that's what I'm trying to explain to the court, is it's clear. We could talk about these records, and whether we get deep into it is because of Ms. Young making an appearance, and all of a sudden we decided we needed to get into micromanaging this. The general topic is this. He had previously been shot 5 years ago. He has been treated at home. He has been treated and committed no crimes. He has been treated at home. His mother takes care of him. They've got all of the supplies already there that they had when he got arrested. They are prepared to let him go home, put him in a wheelchair, take him home, and treat him. But giving somebody a dozen after they went through 24 hours is not, it doesn't solve anything. It doesn't help anything. He goes through that pain.
I want to hear your position on the fact that this was pre-existing the allegations made by the state. So saying that now he is in this medical condition, it was before this. And then there are allegations that involve now, he's only got, I think, 1, and now the state has filed additional attempted murders that have no bond. I do need a set on those.
Sure.
Like, like that's what
Okay.
I'm kind of grappling with. Like, if this was a pre-existing medical condition and you're like, well, he is too medically, complicated for the jail to take care of him, release him back out into the community. He's not a flight risk. He's not a danger to the community, when the state's allegations are that he is, that he committed, according to them, 4 dangerous felonies. What is the defense position on that?
You ran 2 things together, the pre-existing aspect of it.
Right.
Yes, it is a pre-existing, just like the one that you mentioned that was going to pass away. It was going to ultimately die. In my understanding, you released him and he actually did pass away. So that was a proper ruling for compassionate relief. Yes, my client was a victim of a gunshot. That case was prosecuted in this courtroom, or at least in front of your honor. Okay, which my client was the victim in that case. As a result of that, as you've court has seen him come in and out with his cane or in a wheelchair, he has been treating for all of that, just like somebody had cancer and then goes to the jail and deals with it. He had all of his pre-existing and was being treated fine at home and tried out in the community and was fine. And coming here, and all of a sudden he has 3 UTIs within the first 90 days. I asked the family just to hold off. Let's get him treatment. Judge Kite's going to want to know, did we address it with the jail first? And that's I held off on filing my motion because the last UTI report that's in the medical records was in September, and it says in there it's because he's not getting the care that he needs. The nurses are not giving it to him regularly. That's in the that's in the University of Florida doctor, the physician who was seeing him, the urologist who was seeing him, is the one saying that, not me, not anybody else. He's not getting the medical treatment at the times that is necessary to prevent the UTIs and the pain that goes along with all of the infections that go with that. All of that was pre-existing. The jail, with the NAFCare and with all their contracts, and we're not living in a vacuum. There's a camera here that we know what's going on. There's all kinds of lawsuits. There's all kinds of litigation. I don't expect them to come in here and say, we can't treat him and then jeopardize their contract with the sheriff's office. They're going to come in and say, we're doing everything we can. We can do it. He's not cooperating. That's when this whole hoarding came up out of nowhere, trying to.
I'm past that, Mr.
Thank you.
Barrett.
But the point of it is, they're trying to defend themselves when they could simply go, it is better to have him at home with us. Next, the court mentioned release him into the community. I'm not asking him to be released in the community. I'm asking for house arrest. I'm asking for him to be at home. You can put a GPS monitor on him. If he steps off that property, other than to go to a hospital visit, doctor visit, I won't even require him for an attorney visit. I'll go to his home. We're not trying to release him into the community for these dangerous felonies. Never been arrested before. This shooting where he was the victim was 5 years before. Not to get into the facts of the case that we have before you.
Right.
There was no communication, no threats, no posts, no Facebook, no there's nothing at all that connects the two of them for 5 years. But then supposedly they run into each other, and the allegation, we'll get into the allegations of the case as we go forward, but to suggest that my client, I don't want to get too far into the
So
facts.
what are you saying? You're saying that he's medically declining because he's incarcerated.
Yes. Yes, I mean, the records are showing that his health is declining. I'm not asking to be released into the community. I'm asking to go home on house arrest. The reason I mentioned that if the court felt more comfortable, the state felt more comfortable, that if something were to happen and you wanted a bail bondsman to find him, we could put a $50,000 bond. I understand we could set all of the bonds at $1 million, and I'm still going to ask you for the compassionate relief. We can add 3 new bonds of $500,000 apiece, and I'm still going to ask you for an ROR compassionate relief. I'm not trying to make a $500,000 bond. I'm not here as a normal bond hearing or a bond reduction motion. I'm here for compassionate relief, Your Honor, and I believe the records have shown it. That we are acting in good faith. The reason we went down this road is so we wouldn't misrepresent anything. I'm trying to provide all the medical records to you that we can. We've done it. We've tried to go through it as quickly as we can because this has taken on a life of its own. It's taken 2 months. And I appreciated the court starting it with the medical aspect of it because that's where we're at. The man has never committed a crime before this. He's never been arrested before this. To suggest he is a threat when he didn't even, there's no showing of any beefing, any problems, no gang activity, no nothing. From when my client was a victim and shot and was testifying in a court of law as a victim in the case to getting here. He hasn't changed. He's been home. His mom's been taking care of him. His sister's been taking care of him. We're just asking for the next 3 or 4 months while we litigate this, that we allow him to be at home. We don't have to worry about the jail. We don't have to worry about NAFCare. We don't have to worry about if he's going to fall. We don't have to worry about if he's going to get another UTI. We don't know if he's going to get sepsis. These are the things that are in front of the court, and we're asking respectfully to allow him to go home for that. Not into the community. House arrest. Not community control, not ankle monitor within GPS, certain distance. Home, house arrest is what I'm asking for, Your Honor. Thank you for allowing me the time.
Yes, sir. All right. what is the state's input for the unset charges?
Your Honor, the state would ask for 250,000 bond, no victim contact, and GPS for each.
And the state's request on 5 is 100,000,
Yes,
three,
Your Honor, that's what we had agreed to.
a reduction there.
Yes, ma'am.
All right, this court, having reviewed the materials given to it related to the bond motion, and will operate off of what has now been filed on docket line 204. It encompasses a number of hearings that have started / taken place throughout a time period that has been referenced on the record, starting in October, concluding today. The testimony before the court is that Mr. Townsend and the evidence that has been stipulated to by both sides that this medical condition was pre-existing the allegations of the state of Florida. The state of Florida has raised and filed allegations in this court. He was arrested on one, and they have increased the number of dangerous felonies from one, and they added 3 additional. Those, that is 2 through 4, carry no bond with it because there is because there has not been a pretrial detention motion filed. Now, this court, he is entitled to a bond. However, this issue, the court has to analyze tandem statutes. That is, that while it is true there is a favor for non-monetary pretrial release, and it is to ensure the appearance of defendants to face charges brought by the state. However, homicide and attempted homicide is also covered and classified under a separate statute, which is 907.041, where the legislature has implicated, and it says it isn't the intent to create a presumption in favor of release. However, that presumption does not necessarily stay with individuals where the state of Florida has brought charges and defined them through their information as a dangerous crime. Homicide is 5A9, and the attempt is also covered. So it is not it is not a situation where an ROR or something like that, this court has to have the ability to monitor. If he does make a bond, that it is incumbent upon the bonding agency to locate Mr. Townsend. If he were to make that bond, I would deny any request that I would ROR him with a house arrest because this court finds that it is compelled by statute to set some type of monetary bond. So now it has been raised and it was set in first appearance, count 1 at 350,003, count 5, 300,003. By agreement, the court will go through with it. As to count 5, the court will grant the motion to reduce the bond to 100,003. The issue seems to be on count 1, and I find that there is not, there is maybe a concern and an issue related to his care. However, the court does not find that that is basically a change in circumstances to the extent that any medical condition that pre-exists and is being managed by the jail would necessitate a reduction. So as to count 1, this court will deny it. Now, counts 2, 3, and 4, the court will give consideration that those facts were lying within the facts and circumstances submitted to the issuing magistrate that set bonds. However, the court never has the authority to set bonds in relation to uncharged crimes therewithin. The state has defined it now. They've now charged 2, 3, and 4 in consideration of the bond not being reduced as to count 1. However, the facts being existing at the time, the court will not set the bond at the amount requested by the state. However, they will be lower in consideration of the bond not being reduced. Therefore, the court will set the bonds as to count 2 at 75,003. Count 3, 75,003. Count 4, 75,003. If Mr. Townsend does make a bond, the court will amend the previous GPS order and make it for house arrest, not GPS only. When would you all like your next court date?
I'll defer to defense.
I'd like to go ahead and set it for trial. It's been set multiple times.
2 questions. One was, when do we want it set? I was gonna, for next court date, any day the week of the 12th, January 12th would be acceptable for our next court date.
Give me a date.
Yes,
I'm here.
Thank you. 14th, Your Honor.
Yes, sir. January 14th, 9 a.m., and that's for pretrial. When would you like to set it?
Your Honor, Detective Scott is going on maternity leave. I believe she returns at the end of April, beginning of May. The lead detective in this case.
How much work needs to be done for it to be ready?
Did I hear, when did she, I heard April or May. I'm sorry, I didn't hear it all.
End of April, early
And
May.
then the court asked how much more work. There is at least one victim, and I believe Detective Scott also still needs deposed.
And I've developed some issues with the defense. Just so, again, my hearing, I apologize. Are we talking about trying to get something after she returns from maternity leave, or do we know, are you trying to get something in February, March, or are you talking about after she comes from maternity leave?
No, I mean, I would need something after she returns from maternity leave, but the issue is she has not been deposed yet either.
Right. Well, we can get the deposition done. Ms. Posey and I will schedule that deposition.
When does she go out?
That's what I need to ask her again. I know I have a note on my desk. I just don't have it digitally written down.
I mean, obviously, if we're going to set it 1st of May, that any week would be available. That's more than enough.
Is that what you want to do? Or do you want to get it done sooner?
I'd like to get it done sooner. But I also recognize lead detective, and if I wanted March or April, that's going to be a problem. Can we just go to the 15th, Your Honor? Just that we can figure out if we'll have that deposition done, and see if there's a way to resolve this short of a trial.
I'll see you then. January 14th, 9 a.m. pretrial.
Thank you.
Thank you.
Have a great holiday.
You too. Good morning.
We can next address Sean Piles. He's number 2 on the court calendar.
Good morning, Mr. Piles. Raise your right hand to be sworn in.
Undo.
Your Honor, the state would like to call Pete Venuti. He's in the anteroom.
So let me take up the Golden matter before this, okay? I'll see you in a moment. Let's get Mr. Golden in the chute. Good morning.
Good morning, Your Honor. Good morning, Your Honor.
If the attorneys will place their appearances on the record, please.
Assistant State Attorney John Kalinowski for the state of Florida.
Thank you.
Kenneth Williams for the defendant.
Thank you. Good morning. We passed this so that the defense could call additional witnesses in mitigation. Do you intend to do that?
Yes, Your Honor.
Okay. Mr. Golden, why don't you go ahead and have a seat? Call your witnesses, please.
Yes, Your Honor.
Do you want to be seated?
Yes, please.
Okay. Mr. Kalinowski will give way.
Yes, Your Honor.
Thank you. Good morning.
Good morning.
Mr. Williams, why don't you go to this podium, all right?
Okay.
Okay.
All right, you may proceed.
Thank you, Your Honor. Good morning.
Good morning.
Would you state your full name and spell your last name, please?
Tony Harden, Harden.
Mr. Harden, are you related to Justin?
Yes, sir.
How are you related to Justin?
I'm his grandfather.
Does that mean that you have known him all of his life?
Yes, sir.
And during that period of time, you have had an opportunity to observe his character, have you not?
Yes, sir.
Would you tell the court what kind of character he possesses?
He's a kind, loving grandson. Anything I asked him to do, he would. He's not a mean person. Not that I know. And he stayed with me for the summer time together. And me driving trucks, I spent time with him, working with him. But he is not a mean person. He's not a person to hurt nobody. So, I looked at this an accident. How can you punish somebody for an accident? That's what I keep asking myself. If I accidentally step on somebody's feet, I wouldn't want you to punch me. If I accidentally do something, I wouldn't want you to punish me. Now, if I deliberately done it, that's something else. If I thought that he did that deliberate, I wouldn't have no problem. Yeah, you should be in jail, but I don't think that he should.
Where do you live, Mr. Harden?
I live in Statesboro, Georgia.
There's a university there, isn't there?
Yes, sir.
What's the name of that?
Georgia Southern.
Georgia Southern, yeah. My son-in-law went there. During the time that you had your grandson stay with you, have you had the opportunity to give him responsibilities?
Yes, sir, all the time. I mean, by you being in Georgia, I'm working all the time. I'm working around the house. We ain't been long bought a house. And, he helped me clear the trees out. I mean, he's there with me, and I raised 4 girls.
Yeah, let me ask you, I apologize.
Yes, sir.
How is he or has he been about discharging responsibilities that have been given to him?
Good. Been great with it. I don't have no trouble out of him. Never.
Has he discharged his responsibilities grudgingly and not wanting to do so?
No. Not with me. I mean, anything I asked him to do, no problem. He don't be mad. He just do it because I let him know I'm teaching you. I'm teaching you, son, how to be a man. I'm teaching you how to take care of your family. That's the way, that's the way I taught all my children.
Have you observed him taking care of his family?
Yes.
How has he discharged that responsibility in front of you?
Christmas time, he'll bring the kids to me. I remember one time he called me and said, "Granddad, I don't have a job. I need some money." And I told him, I said, "Son, look here." I said, "Now, Grandpa gonna send you this money this time, but I need you to get a job. I need you to go to work and take care of your family. This is what a man do." And as I told him that, he got a job in a warehouse and went to work and taking care of your family. You need to buy Pampers. You need to, whatever need to be done with them kids, you need to do it. And every Christmas, they would bring them to me, and I would take pictures. We on the bed, and that's what we used to do as a family. And this right here kind of hurt me because I don't, I'm wondering, why is you looking at him like he's a mean person?
Yeah, let me interrupt you. I apologize. At the time of this incident, do you know whether or not he was working? Whether or not he had a job?
I don't know.
Okay.
I don't know.
All right. And is it your purpose for being here is to enlighten the court about his character, correct?
Yes, sir.
Right. And ask for a fair and just sentence?
Yes, sir.
All right. Then that's all I have at this time, Your Honor.
Thank you. Cross.
Yes, Your Honor. Good morning, sir.
Good morning.
Since you mentioned that this was an accident, have you yourself seen the video of what happened?
No, sir, I haven't.
Okay. All right. That's all I need to know.
Okay.
Thank you very much, sir.
Okay.
I don't have any questions.
I don't have any follow-up.
All right, thank you, sir.
Yes, ma'am.
You can step down.
Okay.
Okay. All right. Call your next witness.
The next witness is by Zoom.
Okay.
We have Zoom info, correct?
Who is it?
Kye Golden.
He's using a Motorola.
Is there a Terry Golden on Zoom? If that's your name, if you would please activate your camera and your microphone. Good morning. Can you hear me?
Can you hear me well?
Can you hear me, sir?
Yes, I can.
All right, tell me your name.
My name's Terry Golden.
All right. We're going to adjust the board so that you can see your son. Do you see him?
Okay. Not at the moment, I don't.
You've got to, if you're using a phone, you've got to swipe over to a different view to be able to see the courtroom.
Okay. Okay, yes, I'm seeing everybody in here now, so yes.
All right, so you see your son. Is that right?
Yes.
Okay. Mr. Justin Golden, do you see your dad?
Yes, ma'am.
All right. If you'd raise your right hand, please, to be sworn in as a witness.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Hold on. Accept the other participants. All right. All right, thank you. All right, you may proceed.
Thank you, Your Honor. Mr. Golden, do you see you told the court you see your son, correct?
Yes, I do.
And you recognize this person to be your son?
Yes.
Right. And I take it you have known your son all his life?
Yes, correct.
And so you've had an opportunity to observe his character all of his life, correct?
Yes, that's very correct.
Would you tell the court what kind of character you have observed your son to have?
Well, his character, he's becoming a young man, became a father, and the type of character I see, he's a nice person. He's a very, very helpful person. There when you need him, he tries to give you a hand anytime he can, any way he can. He was since he had his kids, he was I would think he would be a very great father because he always called me or texted me, almost every day, every other day. And he had his kids, and he was with his kids, and he was either maybe doing something for his kids or, trying to get a job and get himself stable, to get something together, to be able to take care of his kids, and he was, since he had, kids, he was looking to do different, and more things and better things, but, he'd tell me, I'll wait until, the kids get a little older, then he want to go do this and want to go do that. So he was a person who was, looking to get his, together and get on the right track.
Have you observed him discharge responsibilities?
No, I haven't. No, I really can't say I haven't. If you pretty much ask him something, or ask him to do something, you pretty much do it. If he had something go wrong, had a problem, he'll let you know I had a problem. This and what. So he always try to take responsibility for anything that he done. If he done anything.
Have you observed him parenting with his kids?
Yes, I have.
What kind of parent would you say he has been?
I would say he's been a good father, a learning father, because he was a new father, but he was a good father. Like I said, he would call me almost every day, you know, maybe he needed something for the kids, Pampers, diapers, or pops, I'm going to get this, I'm going to do that, you know, I give him helping hand if I could, and I would, because I know he would, you know, he would do the right thing, you know. So I would think he was a great father, and he always had those kids. Every time I talked to him, every time I seen him, he had his kids, he had those boys. So I was going to be a great father.
Have you ever observed or witnessed him to intentionally put his kids in harm's way?
No, I haven't. I've never myself witnessed anything like that. Like I said, he was he had his kids, and when I talked to him, he had his kids, and he did the most to protect his kids, and did the utmost for his kids. And like I said, he was a young father, and he you know, just getting started out, so he's trying to get himself stable and this and that, but I've never seen him in my eyes do anything that was toward those kids. All my conversations with him is someone helping for those kids where he needed anything, or where he needed advice on anything, or what, you know, anything he wanted to do, he was always looking in the positive direction.
You have known, excuse me, you have known him to attend middle school and high school, correct?
Yes.
During those years, were you called out to any school for him giving trouble while at school?
I myself wasn't. No, I was not. Like I said, I live in Georgia, and you know, for a lot of his middle school years and in those years, he lived in Florida. So I haven't personally got any call to have to come there to his school. But I can vouch for, you know, as his mom, me and her having contact, having the problem, he wasn't a bad kid to give me any problems, you know, like that. In my knowledge of.
Do you know him to be a person who has and knows how to follow rules and regulations?
Yes, in my eyes, you know, yes, I feel he is. I feel he very much is. He's not he wasn't a bad guy. He's not a bad kid. This would be his first time, you know, getting in any trouble, you know, of law-wise, you know. So he's very much
Mr. Golden,
yes.
make sure that when you're talking, okay, that you put your camera down so we can see your whole face. We're looking at the top.
Sorry.
Okay, all right. You can continue.
I was just trying to hear. Okay.
Yes, sir.
Yeah.
Go ahead.
And like I said, I'm not looking him to get anything like that and either trying to get any kind of trouble or, you know, he pretty much followed good directions and, you know, he's looking to be a good guy, stand-up guy, you know. Wasn't looking to have any problems, not getting into anything much, you know, a lot of trouble, anything like that. So, to my knowledge, I would say yes, he wasn't that type of person. He's very responsible, things of that nature.
Thank you. You are, and yeah, be careful with your camera.
Oh, yes.
Right.
I think he's trying to hear you, so make sure you're talking right into the microphone. All right, there you go.
All right. Can you hear me?
Yes, I can.
All right. Threw my train off.
I'm sorry.
That's okay. You are Pablo's granddad, correct?
Yes, I am.
So in this incident, you lost a grandson, correct?
Yes, I did.
And you lost it because of Justin's behavior, correct?
Yes, I guess the whole situation.
Right. How do you feel toward Justin, because he is the one who caused the death of your grandson, Pablo?
Well, the way that I feel towards Justin is I love my son, and I know he's not that type of person. This is not anything he would intentionally do, and I will go, you know, to the moon and back for him now, still as I would any day before any of this stuff transpired, and I just think it's a fortunate situation for him, and I really feel like he's just it's kind of an unfortunate situation. But there's no hard feelings, no ill will towards this guy. I know he wasn't raised that way by being his mom, his grandparents, and he's surrounded by a lot of good people in his family. Try to keep him on the straight and narrow and right from wrong. and things to do. So as a feeling about him, I love my son the same. I love him any kind of way. I really just hurt for him because he lost his son and he lost his, you know, in the same place. Now, I don't feel it's necessary to have to, you know, be super down bad punished for, you know, for mistakes that we all make, whether it's here or there, you know, how it goes. But as far as feeling about him, I love my son and go to the moon and back for him. I love him to death, and I know he's a good guy, good kid.
All right, thank you. Thank you very much. That's all I have, Your Honor.
All right, thank
Yeah,
you.
yeah.
Hold on, sir, hold on. The Assistant State Attorney, the prosecutor is going to ask you questions now, okay?
Okay.
All right, you may proceed.
Good morning, sir. Can you hear me?
Yes, I can.
All right. A couple of questions for you. How old was Justin when you and his mother separated?
This was 2011 when we separated, and they probably went to Florida maybe later on in 2011. So I would say he probably was 21 now, so he probably was maybe 6, 7, somewhere around that range. I got the math in my head, but I know it was 2011.
Okay, so yeah, your son was 6 or 7, you think, when
Yeah.
you and his mother separated? Is it fair to say that he was primarily raised by his mother?
Yes. In the household, yes.
And you saw him maybe 4 to 6 times per year?
If you want to say in person, yes. If they come back and forth, I would say more than that. But I would say that's a good number, though, but maybe a little on the important side of that. As far as, you know, video calls and stuff like that, you know.
All right. And you, what state do you live in?
I live in Georgia.
How long have you lived in Georgia?
Pretty much all my life.
And are you a truck driver, is that correct?
Yes, I am.
Okay. Long haul over the road truck driver?
No, I'm not. I was during the point in time some of this childhood coming up. I was a long haul over the road truck driver, but now I own my own. I'm a truck owner.
All right.
Truck business owner.
And since you referred to this incident as an accident, have you yourself seen the video of what happened in this case?
Just a little bit that was shown the other day. The last time I was in the courtroom, that you guys showed it. In other words, I just didn't bring myself to watch it.
Okay, yeah, you were in the courtroom at the first part of the sentencing hearing a few weeks ago.
Yes, I believe that was the first day, so I would say yes, it was probably the first part. Yes.
All right, but you said you couldn't bring yourself to watch it.
I really wouldn't want to watch it whether it was there or there, but I just showed what you guys showed on the screen there, but I just didn't. I just chose not to watch it.
Okay, thank you very much, sir.
Welcome.
I didn't hear you said, repeat your last answer, please. I had a problem hearing it.
I just said I didn't see the video, you know, just all what you guys showed in the courtroom that day, but I just choose not to watch it. I don't have a link to watch it. Nobody ever sent it to me, you know, so I just didn't watch it.
You chose not to watch it. Is that what you're saying?
Yes.
Okay.
Like I said, it never was sent to me to watch, you know, but I'm just saying to myself, I'm not looking forward to watching it anyway.
Okay, I was just trying to hear what you said. Okay, so you said chose not to watch it. Is that what you said?
Yes.
Okay, thank you, sir.
Yes.
Thank you.
Welcome.
All right, any further questions?
I have no further questions, Your Honor.
All right. Do you want him to log mute, and are you excusing him as a witness?
Yes.
Okay. Mr. Golden, Mr. Williams has excused you as a witness. You may remain on the Zoom. However, you need to mute and turn your camera off, sir. All right. Thank you.
I have no further questions. I have no further witnesses, Your Honor.
Okay. Thank you. Is there anything further from either side besides the argument?
I had mentioned at the last court date that I had the photos that I had sent to court, and I was going to make those an exhibit.
All right. So
Record, they are photos.
is there any objection?
I've never seen them.
Okay. Will you show it to counsel?
They were on the...
Just show it to him.
Your Honor, the defense says, view these photos with my client, and we have no objection to their admissibility.
We would seek to admit it as a composite exhibit. I'm not sure what number.
It will be one for today.
Thank you, Your Honor.
Before you argue, it's been some weeks. If you could, I'd like to see that video again.
Yes, Your Honor.
Did you bring it up?
Let me see if it's still on the system.
I'm going to take a 10-minute recess, and so that the clerk can get the evidence up here. Okay. Court's in recess.
Court in recess, please step outside.
You're with the state attorney. You're with the state attorney? Yeah, just, you look familiar. Still no God.
Officer, keep the media to you. Get to touch it.
What?
Very bottom.
AJ, okay, sorry.
I gotta fix something before you look up. Oh, so they already did it. Okay, cool. That didn't meet the media.
All right, we are back on the record. Mr. Kalinowski, Mr. Williams, Mr. Golden are all present. I asked that the video be brought back up. I don't have the ability to play it. So Ms. Webb requested the evidence so that I could, and I only want to view the relevant portions that were previously played. I think that you were fast forwarding.
Yes, Your Honor, I've got timestamps that I can play for the court. I'm currently transferring the video to the desktop so it'll play smoothly.
Okay, I don't have that disc player, so I appreciate it.
As soon as it's done copying, I'll pull it up. Thank you, Your Honor. Is the court ready for me to publish?
Right, if you would just go through the timestamps that you previously played.
Yes, Your Honor.
Yeah.
I'm sorry.
So it can go on his.
Oh, well done, please.
It is, okay.
Yeah.
Yeah. All right, I'm going to start it at 1 minute, 12 seconds on the time part of the video, labeled at 10:38 and 11 seconds as to the actual time. And I'll stop it at 10:38 and 33 seconds, Your Honor, if that encapsulates the primary part of the incident.
Okay, thank you.
Thank you, Your Honor. And I'll give, for the record, that was States 1 that was previously introduced that I was publishing, and I'll hand
The date of that admission.
the date of that admission was November the 13th, 2025.
Thank you. Okay, so there's only argument left
From the state, yes, Your Honor.
in the defense? Yes, Your Honor. All right, I'll hear from the state of Florida first.
Thank you, Your Honor. Having watched this video more times now that I care to count, every time I watch the video of this incident, this death, I am shocked, I am appalled, and I am saddened. Pablo Golden was in a safe place, and it was his father who intentionally took him from a place of safety to a place of danger where he was killed. The defendant, Justin Golden, killed his own child. This is a case more than most that has gotten a lot of inquiries, a lot of curiosity, a lot of people asking me questions about what happened in this case. The first question that I would often get is whether or not this was an intentional act, whether somebody could be so cruel and callous to have intentionally run over their own child. And that is the one thing that I can say is I do not believe that this was intentional. And how cold would you have to be to intentionally have done that? But if it was not intentional, how bad could it have really have been? How much of an accident was this? And we've heard the term accident said a number of times, especially by friends and family of Mr. Golden, that this was just an accident. But how much of an accident was this really? Surely, people would ask me, this had to have been some remote area, some back road, some road that is not heavily traveled, some area out of the way. But no, this was a heavily traveled road. This was Lenox and McDuff near a traffic light within a block or two of I-10. Maybe there was something about visibility. Was it dark? Was it, when this all happened? No, it was in the bright morning light on a clear day. Well, surely Mr. Golden must have put him on a curb or a median or somewhere with some protection. No, he put him directly down on the asphalt next to his vehicle. But he must have been in a car seat, right? There must have been some protection. Who would put their child completely unprotected on the ground outside their car? Well, that is what Justin Golden did. Well, he must have put him at least a few feet away from the vehicle, right? Put some distance between his own infant son and the car. No, he put him right down beside the vehicle. He didn't get out of the vehicle. Mr. Golden, Justin Golden, didn't get out of the vehicle at all. Didn't seem to move or shift out of his vehicle. He put his son right next to the car, not even an arm's length away from the car. Well, maybe he got distracted. Maybe because of the timing of things, maybe there wasn't the ability for him to realize how much danger his own son was in. Well, on that video, the door to the car, the driver's side door, opens at 10:38 a.m. in 19 seconds. Pablo Golden is placed on the ground at 10:38 and 20 seconds, 1 second later. The driver door closes at 10:38 and 21 seconds, 1 second later. And the car is peeling off at 10:38 and 22 seconds, 1 more second later. In a span of 3 to 4 seconds, Pablo Golden went from being safely in the car to being killed and run over by his father. Well, maybe his vehicle had some sort of technical issue. Maybe there was something he didn't realize what foot what pedal his foot was on, or there was some problem with the gear shifter. No, he peels off immediately upon closing that door. He peels from a stop and drove straight ahead without any semblance of caution or care. Well, maybe he kept driving and drove off because he didn't know what happened. Well, all I know from driving for many years is when my tire goes over an object, I feel a bump. I have seen people exercise more care, caution, and concern for a squirrel that darts into the roadway, a lizard that is on the hood of their car. I've seen people act more carefully in a car than the way this defendant did with his own son's life. And that is why every time I watch this video, I am just appalled. And again, saddened because even though this might not have been intentional, if you wanted it to be, it would look exactly like what this is. And I understand that Mr. Golden's family loves him and want him home and call this an accident, but I'm also aware that it seems like it diminishes the life of Pablo Golden, the way that his life is almost dismissed. Like it's a shame that he's gone, but it was an accident and we all need to move on. Pablo Golden was a child. He was a life. He was loved. He was cared for. He had a life ahead of him, and that life was taken away from him unfairly and much too soon. The guidelines in this case call for a minimum sentence of 13 years Florida State Prison. But I believe the facts in this case warrant more than that. The defendant callously acted and caused the death of his own child. The state is requesting a sentence of 25 years, Florida State Prison. Thank you, Your Honor.
Thank you. Have you shown the score sheet to the defense in the case?
I would have emailed it, I believe, back before the first sentencing hearing, so I can show it to Mr. Williams again if he...
I want to make sure that you agree with the score.
Defense does, Your Honor. The score that's in the score sheet.
Right.
Yes.
And you scored the injury points at death, 120 points.
That is correct. An aggravated manslaughter of a child is a level 10 offense, which is the highest on the sentencing guidelines.
All right, and you agree with those scorings?
I do.
All right, thank you, sir. Let me hear from the defense.
Thank you, Your Honor. May it please the court.
Yes, sir.
First, I would like to acknowledge the manner in which this court has discharged its duty in this case. Excuse me a minute, may I?
Yes, sir. Yes, sir.
As I was saying, I would like to acknowledge the manner in which this court has discharged its duty in this case. Your Honor has been fair, kind, and patient with justice and the state and the defense team, and we thank you. Second, I also commend Mr. John Kalinowski with the exemplary way in which he has gone about prosecuting this case. I was an assistant prosecutor once, and I have handled hundreds of cases as a defense lawyer against prosecutors, and not all of them are alike. John, in my view, handled this case with aplomb, equanimity, and the rumination a case like this requires. Justin is now 21 years of age, having observed a birthday November 1st while incarcerated. He is a first offender. He has no juvenile criminal history. He attended church. He has close family members and ties to this community. He had 2 sons before the death of Pablo, the death he carelessly caused. He is extremely remorseful and sorrowful for causing the death of Pablo. He has told me that he wishes 1,000 times a day that he had not caused Pablo's death, that he is haunted by the fact throughout every day that he caused Pablo's death, and that Pablo is not alive today and will not have an opportunity to mature in life in the future because of his stupid and impulsive decision. He has told me he has learned and is learning his lessons about this every day. He realizes his behavior constitutes criminal conduct. He understands he must be and justly deserves punishment for his criminal behavior. He asked this court to mix justice and mercy in its punishment. I am reminded of the swearing-in ceremonies of judges in the First Judicial Circuit, where I spent most of my legal career, where inter alia, the Code of Hammurabi is referenced, and invariably a text from the book of Micah, chapter 6, verse 8 is read, which says, "He has shown you what is good. And what does the Lord require of you? But to do justice, and to love mercy, and to walk humbly with your God." I also referenced the words of Chief Judge Frank Caprio of the Rhode Island Circuit Court when sentencing a wealthy socialite young white female who was charged with reckless driving and speeding 70 miles per hour in a residential neighborhood. When stopped by law enforcement, she displayed no remorse or compunction for her behavior, and indeed, 3 days later was stopped for the same offenses. She then went on social media and berated the officer who had the temerity to stop her. Judge Caprio said, "When a judge sentences, just as I in this sentence, we seek to drive home the seriousness of the criminal behavior. We are not trying to be cruel. We are not trying to destroy lives. We are trying to do several things at once. First, we are trying to punish the wrongdoing. Yes, punishment is a part of justice. Second, we are trying to deter that person from doing it again. Third, we are trying to send a message to others who might be watching that this behavior won't be tolerated. Fourth, and this is important, he said, we are trying to protect the community. We should aim to be firm but merciful and impose a sentence that punishes but also offers a path to redemption. Compassion without accountability is not compassion at all. It is enabling. The defendant must be made to know that the behavior is dangerous and unacceptable. But the defendant should be given an opportunity to change and do better. I have come to know and regard Justin as one of my own 3 adult children, 2 sons and a daughter. I point out to the court the obtuse criminal behavior Justice engaged in did not involve multiple victims. It was not done for monetary gain. It was not heinous or cruel. And Justin recognizes and admits his culpability. I ask and know the court will impose a sentence that takes into account the gravity of the crime, but is also combined with mercy. There is no hue and cry from the community or family members for a harsh sentence in this case. I have talked to many individuals in this circuit and other of the 10 or more circuits I regularly practice in. While not divulging the identity of my client or violating confidential privilege, each person I talked to said whoever engaged in such behavior is surely guilty. When asked, should that person receive a harsh prison sentence, 100% of them said no. That is surely not a scientific poll, but it gives some idea how citizens of the state of Florida feel about a crime of this nature, for what it's worth. I recognize the guidelines, but on behalf of my client, I therefore respectfully ask this court to depart from the guidelines, to go below the guidelines, to adjudicate Justin guilty of the offense he has pled to, sentence him to incarceration of 12 plus 12, that is 112, and then consecutive months in the county jail, followed by 2 years community control, followed by 5 years probation, as a condition to perform 500 hours of community service work, pay requisite fines and cost, 5 years suspension of his driver's license, and attend driver's education school. Thank you for listening to me. Now, Mr. Golden would like to address the court.
Before he does, did you want this court to analyze along any particular subsections of the downward departure statute? Are you submitting?
I understand. I didn't jot those down, Your Honor.
They're on the guideline sheet. Do you have that?
I do, Your Honor.
The mitigating factors in 921, if you want to point me to those.
Yes. May it please the court.
Yes, sir.
I'll make reference to, and I know that they're not numbered, but this is right at the top, which says Mr. Golden's plea was legitimate and uncoerced. And then drop down to where it says the defendant cooperated with the state to resolve the current offense or any other offense, but here the current offense at any stage where we're asked he has cooperated. The offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. Last, the defendant is amenable to the services of a post-adjudicatory treatment-based drug court program and is otherwise qualified to participate in the program. So those are the four that I would point out.
Yes, sir. I don't recall any evidence related to any drug issue.
No, there is not. But
Okay.
I checked it just in case.
Yes, sir. All right. Thank you.
You're welcome.
And you said your client wants to address the court?
Yes.
All right, Mr. Golden, come forward.
Good morning.
It's an allocution, correct?
Your Honor, may it please the court.
Yes, sir.
I spoke with him last evening, and the information he's going to give to the court, I got from him, and I reduced it to writing. So he's going to read that to the court.
Yes, sir.
Okay.
Good morning, Mr. Golden.
Good morning. I cannot completely tell the court how sorrowful I am for the stupid and criminal conduct that caused me to kill my son, Pablo. I take full responsibilities for my action, and I make no excuses to blame no one else. While I did not intend to kill my son and had no criminal intent, I know that is not enough. I felt as his protector, as his father, and I was the monster who killed him. I deserve judicial punishment. While I suffer from what I caused, I know my actions which caused the death of Pablo have caused many loved ones, mine, his, even those in the world that don't even know him personally, to suffer in their pain cannot and never will be erased. While saying I'm sorry is not enough, still from the bottom of my heart, to everyone, including him, his family, my family, and those that are viewing, I apologize.
Yes, sir.
That's it.
That concludes it. Yes, sir. Thank you.
Do you want to ask him any questions?
No.
Thank you, Your Honor.
Thank you.
Thank you for your attention and for listening to us.
Yes, sir. Thank you. All right, the court will be in recess to consider the sentence.
Recess outside.
A couple of housekeeping matters before I proceed. I want to make sure we did address the pre-sentence investigation report, and there were no, thank you, there were no objections or corrections that needed to be made to that.
We didn't address it.
We did not? Okay.
But if I may say, the defense agrees with the report and what it says, and we have no objection to it.
Okay, I wanted to make sure. I couldn't recall whether we addressed that on the record or not, so I appreciate that. Was there anything on behalf of the state of Florida?
No objections or exceptions to the pre-sentence investigation.
And because this is Mr. Golden's first allegation of a felony, and that was prepared, and so the court has reviewed it. And just as I asked the state of Florida to publish the video for me again, because it had been some time, I think it was November 13th since I had seen it, I do want to say for the record, I did go back through the letters that were submitted to the court. I reread the pre-sentence investigation report, as well as there were several letters on the docket that were filed by family members and supporters of Mr. Golden. And so I did want to put on the record that I did review all of those things before I determined what an appropriate sentence in this case would be. And so what I would ask is if you would approach the podium, Mr. Golden, and please present yourself to the court for sentencing. And as he's doing so, the state of Florida indicated as a result of his plea of guilty that you would drop the second count, which is vehicular homicide. Would you announce that now?
Yes, Your Honor. The state will announce the all prosecuted 30 is count 2 vehicular homicide.
And as far as the court costs, the sentence that would be imposed in this case would carry with it the statutory court costs in the sum of $518 plus a $100, that's including the $100 cost of prosecution fee.
Yes,
and there's an application fee of $50. Does your client object to that?
No, Your Honor.
Okay. Mr. Golden, your attorney has requested that this court consider departing from the guidelines, and that requires an analysis of whether there are certain mitigating factors that exist that are basically substantiated by evidence in the case. Among the factors that this court considered based upon your attorney's request, I did do so. I do find that there is evidence sufficient to support a departure related to subsection J. However, it was, and then also the other two, there is evidence of those things. That is that you entered a plea. It was determined by this court to be legitimate, and you did not engage in any type of extensive discovery in this case and accepted responsibility legally through your plea. And so those three, this court finds that there is sufficient evidence to downward depart. However, subsection M that was submitted to this court related to any type of treatment for drugs, I do not recall any evidence of that. Additionally, this court finds that based upon State v. Avery, that is 384 Southern 3rd 321, that is a 5th District case, 2024, that there is not sufficient evidence to support any type of downward departure sentence related to that particular subparagraph, which is M, for the record, 926. 2M. So is there evidence to do so? Yes. Does this court choose to exercise its discretion in doing so? The answer is no. And how I come at that is that I have evidence to do so, but I choose not to. the first and foremost thing that any judge, any court in this state must submit itself to the law, the rule of law. And what I have before me is all I'm considering. But it is important that we consider what you have basically entered a plea to and what you're accepting responsibility for legally. That is that you have pled guilty to aggravated manslaughter of a child. That requires the state to prove three things. That is that you, by culpable negligence, neglected your son. And as a result, you caused the death of your son. And at that time, you were the caregiver of your son, and he was a child. And so what does a caregiver mean? I'm reading from the law. It says it means that it is a person who has been entrusted with or has assumed responsibility for the care. Your son was 8 months old. So culpable negligence for a child in a factual context of that is, it's been submitted to this court that your child was 8, okay, 8 months old. And I will read this because it was submitted to this court through the testimony of some of your family that this was an accident. The law describes accidents this way. It says every person has a duty to act reasonably toward others, and if there is a violation of that duty without any conscious intention of harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter causing the death because of a merely negligent act. So your grandfather coming up here and saying that, you know, you shouldn't be punished because it's like stepping on someone's foot. It's like a total accident. That is not before this court. You legally could not be before this court. You may be in a different court, but you wouldn't be in front of me. It's not that. Can never be defined as that. Okay, so I'm going to continue. But culpable negligence is more than a failure to use ordinary care toward others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or a grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of another. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. That's what I would have said to a jury if you chose to do so. When they found you on that day, the PSI documents this. It says that when they talked to you, you said that you had been in a verbal argument with Miss Whitby, and that when you stopped the car at that light on McDuff, that she got out. But before she got out, she turned around and she grabbed your infant son and she put him in the passenger seat. All of that was enclosed in the car that you were driving. No one really probably would have ever known what was going on between you and Miss Whitby, but that's bad enough that she took your child out of a car seat and put him in a passenger seat. And then I'll continue. It says that at that point in time, you said to the police that you didn't want to be responsible for the child, nor accused of anything with the child. And that's kind of where it gets redacted and ends for me. This is outside looking in. This is a witness's statement. This was a witness that was behind you and Miss Whitby in the light, at the light. She said she saw a female exit the vehicle with nothing in her arms and walk away from the vehicle. She observed the driver's door, that's you, It's open, and the driver placed something next to the vehicle. And then she describes, I'm reading a little bit out of order, it says that she thought that what you placed in the road was trash. Then she said she saw the GMC drive over the item. She saw it move. And then that's when she realized that it was a child. She said the GMC slowly closed the door and slowly drove away. Mr. Kalinowski said that he gets lots of questions that he has offered this court explanation for. My thought is that there is no way to explain the inexplicable. There is no reason. There doesn't have to be a reason. The only thing that this court has to do is never asked to explain why something happens, only who and what. Who did it and what happened? And is that a crime? And when those questions are asked, either by answered by either a jury or a plea, it's left to the court to say what is just and right in a case. And so I have considered all of the mitigation. I don't believe that 1 year in the Duval County Jail, followed by any length of community supervision, would suffice for the gross and flagrant conduct, the act. So that is why this court is not going to exercise this discretion in sentencing you below the sentencing guidelines. And so what I'm left with is a young man that stands before me, and you, I believe, are everything that your family says that you are. There appears to be nothing that this court needs to rehabilitate, because you are, by all accounts, an exemplary young man that made a terrible choice about his son, that you were entrusted with his care. His mom left, his mom took him out, she put him next to you, and you were entrusted with him, and you violated that trust. As to count one, this court, having accepted your plea of guilty, will adjudicate you guilty. This court will sentence you to 30 years in the Florida State Prison, giving you credit for the days served. How many?
328 days, Your Honor.
328 days. Court's in recess.
Thank you, Your Honor.
Thank you.
Recess. Let's stand adjourned.